prosecution of wage and hour violations, the stakes are getting personal. In several recent cases, the government has penalized company owners and officers for failing to pay overtime, imposing stiff fines and even imprisonment. In one case, the president of a Minnesota sheetrock company was sentenced to 2 years in jail and a potential fine of $3.3 million for intentionally underpaying employee overtime and union pension and benefits contributions. In another recent case, the owners and officers of an Illinois security company were fined over $200,000, constituting back wages and liquidated damages for violating overtime and record-keeping provisions. Under the Fair Labor Standards Act, any employer who violates minimum wage or unpaid overtime compensation laws may be liable for both the shortfall and liquidated damages, which means double the damages. The FLSA definition of employer can be very broad. Along with supervisors and high-ranking executives, it can also include officers and directors. To avoid both FLSA violations and personal liability, employers need to be sure they comply with all the relevant minimum wage, overtime, and other salary and benefit-related regulations and agreements. Otherwise, they may find themselves paying a steep price. While the U.S. Department of Labor is always tracking potential FLSA violations, one case in particular, filed by Victor Farrugia of the law firm of Farrugia Law against SDT Waste and Debris Services and its former president Sidney Torres as a collective action under FLSA for overtime wage violations, put these defendants right in the crosshairs of justice. In 2008, SDT's president Sidney Torres was dubbed by Forbes magazine the trash king of New Orleans because he saw an opportunity immediately after Hurricane Katrina devastated New Orleans to start SDT Waste and Debris Services, a much-needed garbage collection business. It paid off. In the 6 months after Katrina, the company had $24.5 million in gross sales. The issue central to this case was whether SDT paid workers for all the hours that they worked. SDT had a company practice of automatically deducting 30 minutes per day from their paychecks for a lunch break. The law allows an automatic deduction for a meal break. However, if the company uses the auto deduction method, the company is required to give its employees 30 minutes for the break that is uninterrupted by work duties. The big problem was that over 200 former SDT workers were not allowed to take an uninterrupted 30-minute meal break. In fact, SDT installed GPS devices on all of its trucks. If the trucks were stopped for a 10-minute period, a red stop sign would show up on the large screen monitors that the dispatchers were constantly monitoring. The dispatchers were told by management to find out why the trucks were stopped and to tell them to keep moving. Today, for the first time ever, the insider-exclusive investigative news team goes behind the headlines of this lawsuit in a network TV special, Wage and Hour Violations Worker Exploitation, the SDT Waste and Debris Services story, and interviews Victor Farrugia, who successfully settled this lawsuit for $450,000. Victor has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in New Orleans, in Louisiana, and in the United States. His goals, not only to get justice for his clients, but to make sure that everyone is treated with equal respect and dignity as guaranteed under the Constitution of the United States. He has seen many innocent and hardworking people become victims, and because of that, he is driven to fight for people who have been harmed by the willful or negligent actions of others. He has built a substantial reputation by consistently winning cases other law firms have turned down. His amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from New Orleans, Louisiana. It is is my great pleasure to introduce Victor Farrugia to the show. Welcome to the show, Victor.
Well, thank you, Steve. I'm happy to be here.
Tell our audience a little bit about the type of law your law firm practices. What kind of cases do you handle?
Okay, I handle employment law cases
Yes.
from the employee side. And so we handle discrimination cases, race discrimination, sexual harassment cases, age discrimination, disability discrimination, and retaliation cases, also whistleblower cases. And we do protection from overtime wage violations, which are protected by the Fair Labor Standards Act.
Right.
And so it's a variety of cases that we represent employees that feel like their employers have done something illegal to them.
Right. Those are employment cases. You also handle some other types of cases.
Right. Also do some medical malpractice cases and some
Right.
state work.
Right. We're here today because there was a rather large case in a kind of, let's say, notorious case that happened in Louisiana, in New Orleans, right after Hurricane Katrina. And would you tell our audience a little bit about, not the case so much right now, but who you represented? Initially, it was like 400 employees of a company. What was that company?
Yes, that was SDT.
SDT,
Yes, SDT.
Trash and Services Company?
Waste and Debris Services, LLC.
Okay, fine.
Was the name of it.
What'd they do?
Well, they collected the refuge in the city, the garbage. They did residential garbage pickup that comes down the alleys in New Orleans. We have a lot of alleys.
Yes.
And commercial pickup.
And there was a lot of trash right after Hurricane Katrina.
Exactly. And the founder of this company, Sidney Torres, and that's his initials, SDT.
Right.
He saw an opportunity because the traditional garbage people after Katrina were charging increased prices
Really?
to pick up the garbage. And so he saw an opportunity and he started with 1 or 2 trucks and it just built up, and he was charging regular prices, and so everyone went to him because he wasn't charging the higher prices.
So he was really doing the city a great service.
He was collecting the garbage that there was a need for it, and he had a reasonable price, and he started in Chalmette, where he is from, and it just blossomed all through the New Orleans metropolitan area.
Now, eventually, his company grew to how many trucks? A lot of trucks, right?
He had a lot of trucks.
Yeah. And he had a lot of employees?
It was in the hundreds, yes. And
he had a lot of
employees, correct.
And this case arose initially as we're representing 400 of those employees. What was the problem?
Well, the problem was they were not being paid all of the hours for all the hours that they worked.
Yes.
You know, most of them were working overtime. I mean, this company pushed them to work as much as they could. They had the drivers come in early in the morning, 4 o'clock in the morning. They wanted them to work a 12-hour day, and so they get off maybe 3 or 4 in the afternoon.
Yeah.
It was a lot of work, and they just the problem was they weren't getting paid for all the hours that they worked.
What should have they been paid?
Well, they should have been paid an extra 30 minutes a day because they were taken out, 30 minutes was taken out every day for an automatic deduct for the lunch period.
Yeah, so in other words, you're entitled to take a lunch break, 30 minutes, correct?
Exactly.
Right, and the company automatically took that 30 minutes, took that 30 minutes of pay away from their pay, correct?
Correct, that's right.
But they didn't allow them to eat lunch, correct?
That's right.
An uninterrupted lunch break.
That's right.
Right. And how do they do that? I understand they monitored the trucks. They had GPS in the truck, right?
Exactly.
So they would be able to see if a truck stopped someplace,
Right.
and they would contact the driver and said, "Get moving."
Exactly.
Right?
That's exactly what they did. They had dispatchers that would monitor the trucks, and on the screen there would be a little stop sign that would show up on the screen, a red stop sign that if the truck was stopped 10 minutes, then it would show up, and then they'd call the truck and say, "Get moving."
Yeah. Now it seems to me if you have 400 people who are complaining about the same thing, right? that it's kind of an easy case to prove. What were the challenges that you had in proving this case?
Well, the challenges were the law firm that was representing this company
Yes.
was just throwing up every obstacle they could think of to not pay this amount that
What
was
were
owed.
some of those obstacles?
Well, for the first obstacle was the Department of Labor actually investigated this violation.
Yes.
And they found out that there was a violation and that there were like 500 employees that were due some overtime wages, and it averaged out to about 30 minutes a day.
Yeah.
And that was, of course, the automatic lunch deduction.
The lunch break.
Yes.
Yeah.
So, and they concluded that that the company owed these 500 workers about $400,000 or $500,000.
Yes.
The problem is that was never accepted by the company and never paid by the company.
Okay, well, let me get this straight. You got a governmental agency that oversees private companies.
Correct.
People go to them to make complaints, and they come up with a decision that this company's violated the law, correct?
Correct.
And therefore you have to pay the employees.
Exactly.
So why didn't the company pay? I mean, anybody can refuse to pay, but what enforcement powers do they have?
Well, they can go in and
Shut down the company, can't they?
yeah, they can go in and enforce. However, what happened in this particular situation, when it came down to, is the Department of Labor going to enforce this
Yes.
against the company was sold. SDT sold out
Right.
and was purchased by a larger company.
Yeah.
And because of that transition, I believe the Department of Labor decided not to pursue it, not to pursue the collection of the money owed.
Okay, so let me
because of the complications
Yeah.
of there being a sale of the company.
Yeah. When a company is normally sold, not only are the assets sold with it, but also the liabilities.
Correct.
Okay, the new buyer, were they aware of this decision by the labor board?
Well, I'm sure that was disclosed. Well, I'm not sure. I've never
Yeah.
seen the
Yeah.
documents, but probably it was disclosed.
Okay.
And in any sale like this, if there is a potential liability, that has to be decided in the
Right.
sale transaction, and usually it's
Yeah.
the seller that has to continue to be responsible for that liability.
So it seems to me the new buyer started following the law, correct?
Oh, absolutely. Yeah,
Okay.
in fact, we had drivers, a lot of drivers continue with the new company.
Right.
And in the first month of the new company, they had a big meeting and said, we will have a lunch break.
Okay.
We will stop the trucks for 30 minutes.
Yeah.
You will not be driving during the lunch break.
Yeah. So-
And everything changed with the new company.
Yeah.
It was
So-
a simple thing to do.
Yeah. So it seems to me here you have this, this order by the, a governmental agency saying you got to pay these people. Company sold. We need a law firm now to pursue this, right? And make sure that $450,000 or whatever it was is going to get paid, right?
Right.
And that's where you enter the picture, correct?
Exactly.
Okay.
Exactly.
So it seems to me that if you have a government order to pay, it's a pretty simple case to enforce that. What were the problems?
Well, the problem is you have to file a lawsuit
Yeah.
in federal court.
Yes.
And you have to get a judgment, and then you have to execute on the judgment. So we had this case set for trial, and we had to take depositions in the case. We had to prove our case.
Yeah.
We had to, as de novo, you had to prove the whole case from scratch.
Despite the fact that the government has said these people have violated the law.
Yes. Well, you can use their report.
Yeah.
Their report, you can use it as evidence.
Yeah.
But you still have to prove your case. And also, these Fair Labor Standards Act cases are, they're easier than most of my discrimination cases, because in most of my discrimination cases, you have to prove intent. You know, did they intend to discriminate because of your race or your age or your gender? In FLSA, did they pay it or didn't they pay it?
Yeah.
Intent is not there, However, when you go to the statute of limitations, it's a 2-year statute of limitations for violations of FLSA.
To bring a lawsuit.
Yes, so within you can go back 2 years to get this back pay, to get all the pay they owed. But if you prove willfulness, that they did this willfully, you can go back 3 years. So intent does come into the picture as to how much you're going to collect. Are you
Right.
going to go back 2 or 3 years?
Yes.
So the report was very important to prove intent so we could go back 3 years. And in that report, one of the operations officers of the company admitted that they owed the money, that they did violate. It's in the report that he admitted it.
Yes.
So that got us over the hurdle of getting to the 3 years on the
Yes.
pay owed.
So, and eventually the case was settled with only 200 plaintiffs.
Yes.
It dropped from 400 to 200 because you couldn't find the other 200, or what happened? They disappeared.
Well, this is a strategy of the defense
Yeah.
attorneys. They put out discovery requests.
Yeah.
Every plaintiff has to answer all these questions,
Yeah.
these
And
interrogatories.
they didn't want to answer them.
And, you know, these are truck drivers and,
Yeah.
you know, low-income people and not college graduates, most of them. And so they get confused with all this paperwork. You
Yeah.
send it to them and they don't answer it, or it's too much of a challenge for them, or,
Yeah.
you know, so you don't get 100% back.
Yes.
So through
It's
that.
like, it's like a notice when you're involved with a class action, you get it in the mail, and
Right.
a lot of people don't respond, right?
Exactly.
Okay.
So that was one of their strategies. Send them
Yeah.
all this discovery, and some of them will drop out. Well,
Yeah.
that did happen. So we lost about half of the plaintiffs because they didn't properly answer all the discovery.
Yeah.
And so the judge dismissed them.
Mhm.
So we ended up with about 200 that
200.
complied with all the discovery requests.
Right. So you were set for trial,
Set for trial.
and what happened?
And then our strategy was to have a mediator come in to try
Right.
to mediate the case, to settle the case.
Right.
And we were successful in finding a California mediator who has experience with FLSA cases and overtime cases.
Right.
And she came in and she was very good, and we had an all-day session. And in that session, I actually brought in some of the plaintiffs
Yeah.
to be a little more forceful as to
Yes.
how strong our case was. And through her efforts, we were able to finally get a resolution.
Yeah.
But this was 3 weeks before trial.
Yeah.
I mean, they...
Now, let me ask
now-
you this. The defendants in this case initially were SDT, the company,
Yes.
and its former president, Sidney Torres.
Correct. And two of the operations, Mr. Gunlag and
Yeah.
Mr. McDaniel,
Yeah.
were
When
also
you-
defendants. So
Now-
we had 3 individual defendants and the
Yeah,
company.
but SDT was sold to a new buyer.
Correct.
Okay, so the new buyer, they weren't responsible for the past liabilities of the Sid Torres when he was running the company, right?
Correct.
So the settlement was eventually against,
Well, it was against SDT.
Yeah.
And Mr. Torres
Yeah.
made good on the money that was owed eventually, not right away.
Yeah.
It took months and months to finally get the settlement money paid after the agreement to pay, but
Yeah.
finally it was paid.
yeah, in these settlements, for example, in this settlement, it must be a time frame when you have to pay, right?
Oh, yeah, absolutely. And
You know,
that-
like pay in 30 days, 60
Exactly.
days. You're saying
We
months
had that-
and months. What's the problem there?
Well, the problem there was, Mr. Torres just didn't pay it, and
Yeah. And what can
he
you
got
do?
rid of his other lawyers, changed lawyers.
Yeah.
And finally, the new lawyers said, "Hey, you just gotta,
Yeah.
you gotta
The
pay this
settlement's
money."
not jeopardized. You know, he had these people represent him. He has to pay, right?
Absolutely. So he was obligated to pay, but he didn't
Let's-
pay for a few months.
Yeah, let me
Now-
ask.
Now, this goes back. This
Yeah.
reminds me of the settlement conferences we had
Yeah.
while the case was in litigation. It was
Yeah.
in litigation for several years.
Yes.
Well, the bad faith of the company showed up at these settlement conferences with the magistrate judge. In federal court, you can get settlement conferences with magistrate judges. And the first time they went to a settlement conference, they came in, and the costs in the case at that time were, over $50,000. The claims of the 200 employees were in the 6 figures, and the attorney's fees were in the 6 figures.
Yeah.
They came in at that point, the first settlement conference with a magistrate judge offered $25,000.
Yeah. But you can
So,
expect this, right?
Yeah, but they didn't go up on and
Yeah.
the settlement conference. That was it. Boom, take it or leave it. So then there was the discovery started. I was involved in the case then. We took some depositions. They suggested, hey, let's have another settlement conference. Maybe we can resolve this.
Yeah.
So we get to that settlement conference with the magistrate judge. And you know what they offered this time?
What?
Zero.
Zero.
They went down.
What does the judge
It's
what does the
ridiculous.
judge
I mean,
say?
why waste the time?
Right.
What they did, they stopped discovery.
Yeah.
So they said, oh yeah, maybe we can settle this. Okay, we'll stop taking these depositions. So that put us back 6 months and getting the case completed, ready
How
for
does
trial.
a judge get things moving? Because this is insulting.
It is.
This is insulting.
It
How
is.
does a
It's
judge,
ridiculous.
what does he say to the other side? You know, you're wasting the court's time.
Right,
I'm going to
absolutely.
sanction you. Does he do that?
Well, he should.
Yeah.
I mean, you know, magistrate judges are different in the
Yeah.
way they handle these things.
Right.
You know, in this particular case, I don't think the magistrate judge was forceful enough
Yeah.
in putting some pressure on them to come up with a reasonable offer.
Unfortunately, when these cases take this long, a lot of your clients lose faith in the justice system, don't they?
They
say
do.
it doesn't work. You know,
Absolutely.
these guys are delaying, they're
Right.
never going to pay.
Right.
But eventually you were successful. Tell our audience what happened.
Well, eventually we, you know, we took more depositions.
Yeah.
We got good evidence. We took the deposition of all the operational people.
Right.
And we got some good evidence, and we got evidence that would make them look bad at trial.
Yes.
You know, we got some evidence from Mr. Torres that he took his drivers to lunch on Canal Street at the McDonald's.
Yeah.
And you can't park garbage trucks on Canal Street. I mean,
Yeah.
it was impossible. You know,
Yeah.
I don't know why he said things
Yeah.
like that. So
Well,
we had some examples.
Yeah,
of
all I can say is when you sent us the information, you know, and examining everything, you know, he had a great idea.
He
The
did.
city needed cleaning up.
Exactly.
And he gave them an affordable price.
Right.
But with any business, you got to treat people fairly.
Exactly.
You know, you have to treat them fairly. Otherwise, you know, you're harming the same people that you're saying you're helping, right?
Exactly.
So
Right.
let's talk about, the case was set up for $450,000, correct?
That's right.
All right, let's talk about, this is wage and hour violations. In the state of Louisiana, is there a minimum wage?
Well, the state has no state law minimum wage.
Yes.
One of only 5 states.
Yes.
And actually, our new governor is now pushing to get a minimum wage of up to $8 an
Okay,
hour.
when a state doesn't have a minimum wage, the employees have to be paid something that abides by some standard. What is that standard?
Right, yes. That's the federal minimum wage
Which
law,
is?
which is $7.25 an
So
hour.
even though the state doesn't have a minimum wage law, all employees that work in the state of Louisiana are going to get at least $7.25 an hour.
That's correct.
Right.
Unless they work for tips, and then it's $2
Now,
and something.
if the state of Louisiana doesn't have a minimum wage law, do they have laws regarding overtime?
Oh, absolutely.
What are
Well,
those laws?
Well, the federal FLSA law applies to all the states, of
Yeah.
course, and that is if you work more than 40 hours in a week,
Yeah.
you are entitled to time and a half for overtime. So
Right.
if, you know, another extra 50% on your hourly wage for every hour over 40 that you work.
Right.
And the state, in our particular case, most of our employees were working overtime.
Yeah.
So the 30 minutes that they were getting, they were being shorted 30 minutes at time and a half.
Right.
So that was mostly overtime. Now, if they, in that particular week, if they had not worked 40 hours that week, they would only gotten straight time for that 30 minutes.
Yes.
So we had to calculate for each employee, for each week they worked, how much they were due,
Right.
and it took a lot of accounting.
Now, some employees get paid $7.25 an hour, but there are other types of employees that get a lower wage because they're tipped. How does that work?
Right. Well, because they get most of their income from tips,
Yeah.
the employer is only obligated to pay them it's in the $2 range, $2.50 maybe
Yeah,
an
and then maybe
hour.
like restaurant workers,
That would be
stuff
restaurant
like
workers,
that.
correct.
But isn't it the law that, let's say you get $2 an hour, and by the way, the reason that these laws exist is because the restaurant industry went to Congress and lobbied that they would be exempted from minimum wage because, am I correctly understanding that because they might get $3 an hour, because of the amount of tips they might get, it might equal the minimum wage, correct?
Right, equal or exceed.
But what I have often found out in stories, in cases like this, is that when you don't get enough tips to equal a combination making it the minimum wage, that the employer is supposed to step in and add more money, but they never do. Is this right?
Well, yes, I'm sure that's correct. I mean,
Yeah.
I'm not, I don't have any cases specifically about that, but that would happen if you don't get enough tips.
Yeah, now,
They need to step in and pay the minimum wage.
Yeah. Now, is everybody entitled to a lunch break and a rest break while they're
Yes.
working?
Yes, under
Lunch
fair-
break is what, minimum 30 minutes?
30 minutes.
What about rest breaks?
And you get a 20-minute break twice a day.
Yeah.
And a 30-minute lunch break. But the lunch break has to be uninterrupted.
Yeah.
Now, that was the problem in our case here,
Yeah.
is that they told these, all the drivers
Yes.
in the company
You gotta
that
keep
they
moving.
keep moving,
Yeah.
eat
Keep
on the
working.
go, eat
Yeah.
on the go.
Yeah.
So, they ate during the day, but they had to grab a sandwich,
Yeah.
eat it in the truck as they were moving. So
Yeah.
that was the
You
violation.
You said the new governor that replaced Jindal is striving to pass legislation to have a minimum wage.
Yes, Edwards.
Okay.
And West Point grad.
Okay,
Terrific
good.
guy.
He's a Democrat?
Yes, a Democrat in a red state. Amazing. I mean, he has to be
Well, they
good
get
to be
tired of
elected.
Jindal, right? Okay, so we have millions of people that watch these shows, and if you happen to be, if you're an employee, that thinks their wage and hour time rights have been violated, what should they do?
Well, they should, either you have a choice.
Yeah.
You go see an attorney
Yeah.
who handles these type
Yeah.
cases, or you go right to the Department of Labor
Yeah.
and the Wage and Hour Division of the Department of Labor.
So they
There's-
have a division for that?
Yes,
And you
right.
file a complaint?
And you file a complaint.
Now, oftentimes, if you file a complaint or even go to the management and said, you know something, I'm not being treated fairly, they retaliate, they fire you, right?
Exactly. And
So-
that happened a lot in this case.
And that's another legal issue that gets brought up, right?
Exactly.
In a case, because that's a retaliation charge.
Exactly.
Now,
Right.
if a person's retaliated against and they're fired, let's say you're able to prove that they should have been paid properly, do they also get additional compensation for being retaliated against?
Yes, well,
Yeah.
you would have all the damages for being fired.
Yeah.
And if you're fired, then, and it depends, your damages depend on how long you're unemployed.
Yeah.
And whether you find another job making more money or less money
Okay.
than before. So you could have extensive damages
Yeah.
if you're retaliated against and fired for making a complaint
Right.
about your overtime.
Is there anything else you'd like to share with millions of people out there that work every single day that they should be aware of in cases like this?
Well, if you're not being paid your overtime, if you think that you're not being paid all the hours
Yes.
that you're working, you should do something about it.
Okay.
I would complain first to the company, and if they don't do anything about it, then you have your other two options: go to the labor board or
Yeah.
go to an attorney.
Okay, final question. You have a lot of people contact you regarding
Yes.
cases. How do you end up selecting the cases you finally represent?
Well, I usually have them come in for a case evaluation meeting, and we talk about what the law is and who their witnesses are, what kind of documents they have to prove the case.
Yeah.
Because there's no such thing really as wrongful termination. That's not illegal. To be illegal, it'd have to be based on gender or race, because we're an at-will state, and or disability or whistleblower, or one of those reasons.
Yes.
And you'd have to prove that. And in our evaluation meeting, we will look at, well, what kind of evidence do we have? How strong are our witnesses? What do the documents say? What reason did the company give? And a lot of times I'll have them first go to the EEOC for these type of cases and have them do an investigation and find out from the EEOC file what the company's position is.
That does take some time.
Then you can
though.
evaluate the case.
Yeah, but then
Once-
that's, the EEOC takes up
It
to...
take- yeah, well, they they can take 6 months or 2 years or 3 years, you know.
Yeah.
So but it's important, you can ask for a right to sue letter after a few months because they're so busy, they'll be happy to give it to you. But it's important to go there first to get the company's position paper. So then you'll have something in writing of the company's position to evaluate the case to decide whether you should go to trial or not on it.
Okay. All right. I want to thank you very much for spending time with us. You've enlightened a lot of people, including myself. And we will be back again to interview you another time. Thank you.
Well, thank you very much. Appreciate it.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.